Rocky Mountain Mineral Law Foundation, welcome and thank you for joining us for this workshop introducing the complex world of international, interstate, and interprovincial water issues. My name is Eric Martin. I'm a partner at Joel Reeves in Portland, Oregon, and the current chair of the Foundation's Young Professionals Committee. For any of you who may be unfamiliar with the Rocky Mountain Mineral Law Foundation, it's a collaborative organization comprised of attorneys, landmen, and other professionals. The foundation is known for its high-quality educational offerings focusing on legal issues related to mining, oil and gas, energy, public lands, water, and the environment. Beyond the educational aspect, though, of the foundation, the community of professionals that are involved are really one of the high points of the foundation. If you're not already involved, I would encourage you to consider getting involved. If you're a student and you're going to be attending the annual institute in Victoria in July, I'd encourage you to consider participating in the mentor-mentee program and also attending our Young Professionals networking event. That's for students and newer professionals. Before we get started, a couple notes. First, I want to thank the attorneys and host firms at each location. These programs are not possible without their support. After the workshop, please seek out the host attorney in your location and thank him or her for hosting. If you're interested in hosting a future workshop, just let us know. Second, all of the sites are going to be on mute during the presentations. Once the presentations are over, we'll unmute the lines and you'll have an opportunity to ask questions. If you're shy and don't want to ask questions across the country, you can text me your questions and I'll ask them anonymously during the presentation. You can text them to me at 503-505-3650. With that, I'd like to introduce our two speakers for today, Cody DeNoon and Rhett Billingsley. Cody and Rhett's full bios are in the materials that you can access electronically. But briefly, Cody is a Canadian barrister and solicitor whose work focuses on infrastructure and development in international watercourses, dispute resolution mechanisms, and international watercourse law. Cody's currently pursuing a doctorate in the law of international watercourses at the University of Pacific McGeorge School of Law. Rhett recently returned to private practice with Fenimore Craig in Phoenix, where he helps clients with all aspects of documenting, acquiring, transferring, and perfecting groundwater and surface water rights, including Colorado River entitlements. For the past few years, Rhett worked at the Central Arizona Project, which delivers an average of 1.5 million acre-feet of water each year from the Colorado River to central and southern Arizona. I'm thrilled that both Cody and Rhett agreed to share their thoughts and insights with us today. With that, I'll turn things over to Cody.
Thank you very much, Eric. And as I've been introduced, I'm Riley DeNoon, but I go by Cody, so I'm sorry for the confusion. And my presentation, the overall presentation is Waters for Fighting and Creative Compromises, and I would underscore the creative compromises aspect of international watercourse law. It's by far the norm rather than the exception that cooperation is found more than fighting. So I'll go through a quick overview of where I'm going to go with my presentation. My background is in international water law, and so there will be a bit of a focus in regards to public international law. I will talk about the importance of transboundary watercourse resources. I'll talk about public international law and some of the key instruments of that, as well as some of the key principles. And then I'll move on to talk about Canada and the United States and some key instruments between them, particularly the Boundary Waters Treaty of 1909 and the Columbia River Treaty of 1961. And at the end, I'll provide some further reading material if any of you are interested. They're in the slides as well. So the importance of transboundary water, it's a vital yet unevenly distributed resource, meaning that some state actors, some states such as Canada are uniquely blessed with a disproportionate per capita amount of freshwater resources. But as in the case of Canada, often the water resources aren't where populations are. Same is true in California, for instance. A lot of water is piped from Northern California down to Southern California. Populations aren't always where water is, and this is true in the international sense as well. There's 148 countries globally that include territory within one or more transboundary river basins. 310 transboundary river basins globally. Roughly 45% of the world's population live within these transboundary river basins. And transboundary basins comprise more than 40% of Earth's total land area. So you can see it's a really large geographical scope, and it also encompasses a large amount of the human population of the Earth. So cooperation versus conflict. I've alluded to this in the intro, but it's worth saying that as populations increase and as climate change continues, there will be more uncertainty around water resources, and there'll be more pressures on those existing resources. The amount of water on Earth hasn't substantially changed in human history. And so the pressures exerted on those same resources grow and grow and grow. And so as tensions grow, there will be greater sources of conflict, but there's also greater opportunities and reasons to cooperate. And actually, Oregon State University has done some excellent work, some excellent studies into transboundary water resource cooperation and conflict. And they found that there's 600 transboundary water treaties from 1820 to 2007, and 6,400 international water relations events between 1948 and 2008, which show that cooperation more than conflict is the norm. And as I said, however, as pressures increase, the landscape may change a bit, but this norm hopefully will continue. There's also, we see asymmetry in international watercourse. We see, for instance, one riparian may be more economically developed or more militarily developed, or they may have put the water resources to greater use. For instance, on the Nile, Egypt has put most of the waters of the Nile to use and is much more economically developed than, say, Ethiopia. And Ethiopia now is trying to make use and develop their upstream water resources, but they're running into a lot of conflict now with Egypt that has put that water already to use. You also find geographic asymmetry. So you find upstream and downstream. We talk about this very often. Downstream countries generally tend to view water resources as shared. In upstream countries, you'll find more discussion of our water or more of a possessive attitude towards the water resources. And often downstream countries can have some form of anxiety over the fact that upstream countries can have their hand on the tap, so to speak, of such a vital resource, which is often viewed as a strategic resource. So looking at global water resources, the volumes of water on Earth, 97.5% are oceans, 2.5% are freshwater, and of those 2.5%, it breaks down, as you see on the screen, 70% glaciers and permafrost, not readily available for human use, 30% of groundwater, and 0.4% is surface and atmospheric water. That's what we talk about when we talk about rivers, lakes, rainfall. So here we have a map of transboundary river basins in the world, and you can see the geographical scope that they cover. You can see that they don't have a lot of reverence for international boundaries, and you can see how interlinked many countries are hydrologically. We also have, the next slide, is the 592 transboundary aquifers that have been identified as of 2015. And again, you can see how hydrologically linked many countries are around the world and the geographic scale that these aquifers cover. So speaking of watercourses, when we speak about the hydrology, we're talking about a unitary whole. We're talking not just the main surface or channel, the Columbia River's outside here. We're not just talking about that one main channel. We're talking about an interrelated system, the components. We're talking about the watercourse system, catchment area, watershed, drainage basin. And we're also talking about not just the surface area, surface waters. We're talking about subsurface, connected subsurface waters, as well as disconnected subsurface waters sometimes. Human intervention at one point in the system, it's important to note, may have effects elsewhere. And often it's easy to conceptualize the idea of harm flowing downstream. If in Canada, for instance, pours chemicals in the water of the Columbia upstream, they can flow down to the US and they will cause harm in the lower riparian state. But harm can also travel upstream in the sense of dams being constructed on by lower riparians can prevent fish migration, can damage ecosystems. Also, the earlier example I used of Egypt on the Nile, they've put those waters to beneficial use. And in international law, there's a principle not to prevent significant harm. And so often Egypt argues that Ethiopia now trying to develop their upstream water resources by building the Grand Ethiopian Renaissance Dam is actually going to deprive them and inflict harm upon the Egyptians by doing that, by depriving them of water resources they depend upon. So in a certain sense, you can have a forestalling of future development by upstream countries. And this way also you can view that harm can flow upstream in that sense. So a watercourse, as defined in the 1997 UN Convention on Non-Navigational Uses of International Watercourses, a mouthful, but it's perhaps the most authoritative instrument in the field. It says a system of surface waters and groundwaters constituting by virtue of their physical relationship a unitary whole and normally flowing into a common terminus. And you can see here that it encapsulates a lot of what we talked about as far as the hydrological reality of a unitary whole. And one thing that is not taken into account here that's worth noting is unconnected groundwater. So connected groundwater would fall under the 1997 UN Convention, but underground water that isn't connected, often we call these fossil aquifers or fossil water, wouldn't fall under this convention. So here we have a graphic illustration of the hydrological cycle and the interconnected nature of it. And we have a definition from the 1997 UN Convention, which is focused solely on international watercourses, meaning a watercourse, parts of which are situated in different states, borrowing from that earlier definition that I had on the last slide. So the legal order that we situate this in is public international law, and it is predominantly focused on co-equal sovereign states with territorial integrity, the idea of the Westphalian state system. And it's very Eurocentric, but it's the system that we have in public international law today. And it views states as being both sovereign and possessing territorial integrity, meaning that they essentially they have autonomy within their own territory. And if we take this to an extreme, it would, in a transboundary watercourse, you would see that a state might view that they can do whatever they want with the water resources in their territory. In the case of the Columbia, Canada could extract the water, all the water it wanted to. At one point, there was even a plan before the Columbia River Treaty to divert the full flow of the Columbia into the Fraser River, which would deprive any of it from flowing to the U.S., which obviously, if we take the idea of territorial sovereignty to an extreme, this seems correct. And actually, it was most famously espoused, this idea, by in the U.S. Context between U.S. and Mexico by a fellow who it's come to possess his name, the Harmon Doctrine. And on the other end of this scale, we would call it community of interest, which has been espoused in international case law, which sees states sharing an international watercourse as sharing a community of interest, participating in a shared resource. And so we'll see that in international law, actually, it falls somewhere in this scale, not on either extreme, and that territorial integrity and sovereignty is actually limited by the obligations states have to other states. So in effect, we have here a quote from the Trail Smelter case, which happened between British Columbia and Washington State, involving air pollution, and it also involved the International Joint Commission, which we'll talk about later. And in it, you see the principle that no state has the right to use or permit the use of its territory in such a manner as to cause injury in or to the territory of another or the property or persons therein. And it's been built upon in subsequent international case law, the Corfu Channel case, the Gapshnikova and Agramaras project, and the pulp mills on the River Uruguay case, which essentially build upon the idea that states are responsible for the actions taken in their territory that harm other states or individuals in other states beyond their borders. So the 1997 convention, as I said, it was the most authoritative, it is the most authoritative instrument in this field. It was adopted in May 21st, 1997, and in force in 2014. And there was a substantial delay because it required a certain amount of countries to have ratified it before it came into force. And that has been achieved now. 36 countries have currently ratified it. Neither Canada nor the U.S. are parties to this convention. I think that's worth noting. But that they would still be bound under principles of the UN Convention insofar as they represent customary international law. And in fact, the court in the Gapshnikova case stated that the recently adopted, at that point, UN Convention did reflect the basic principles of customary international water law, especially in regards to three key principles from the convention, which are the duty to give notice of planned works that may have adverse impacts, the idea of equitable and reasonable utilization and sharing of water resources, and the idea that states have to act to prevent significant harm to other riparians. But this, importantly, is a due diligence requirement. So it's also important to know that the UN Convention is a framework agreement. It's a general agreement with the assumption that states will go and negotiate more specific agreements between themselves and other riparians that will supplement the UN Convention. So the UN Convention, the procedural obligations here, I've talked about a duty to consult, and many of these are important, obviously, duty to cooperate, regular exchange of data and information, the obligation for dispute settlement, but not all of these have been accepted as embodying customary international law. The most important, obviously, for that purpose is Part 3 here, plan measures on the international watercourse, specifically Article 12, the duty to notify the riparian states of plan measures with possible adverse effect. And then on the next slide, we move into the substantive obligations. These are some of the substantive obligations. Obviously, I've talked about equitable and reasonable utilization. This has been accepted as a embodying customary international law, as well as Article 7, the obligation to prevent harm to other riparians. It's important to note that, again, that's a due diligence requirement. It's a duty of conduct rather than result. And it's important to note that Part 4, I've included at the bottom there, that there is ecosystem discussions of ecosystems and preservation and protection and management in the UN Convention. So treaty law, in some cases, the use of international watercourses will be controlled by treaties. And where these treaties conflict with customary international law or general national law, they will take precedence to the extent that they're inconsistent under the principle that the more specific governs the more general. And although usually these agreements will be interpreted to function in conjunction with international customary law. And in fact, international courts and arbitral tribunals, for instance, in the Indus Waters arbitration, have interpreted existing international treaties to evolve with evolutions in customary international law. And they actually read in ecosystem values into the Indus Waters Treaty that didn't exist prior to the court reading them, the arbitral tribunal reading them in. So Canada and the U.S., a shared history of cooperation. I think it's important to underscore the idea that Canada and the U.S. generally have a very positive, cooperative relationship in regards to shared water resources and are often used as one of the great examples of equitable sharing of downstream benefits, particularly in regards to the Columbia River. So the Boundary Waters Treaty of 1909, it was concluded in 1909 between the UK on behalf of Canada and the United States. It provides governance mechanisms and principles governing boundary waters and transboundary waters between Canada and the U.S. And you can see on this slide a map which kind of embodies you can see what qualifies under the Boundary Waters Treaty, what we're talking about. And it provides a definition of boundary waters in the treaty, in the Preliminary Act, and it essentially talks about international watercourse that forms the boundary between two countries. So in international water law, we often talk about watercourses that form the boundary and then watercourses that are successive, as we call them, that flow from one state into another state. So Boundary Waters Treaty essentially was focused on the Great Lakes. They're a great example of a boundary water that forms the boundary between two countries. But they also encompass under Article 4 other transboundary watercourses that flow from Canada into the U.S. or vice versa. So, and you can see Article 4 down there, a section of it, which discusses the obligation not to pollute water that can cause injury or damage to health or property on either side of the border. So the International Joint Committee was established by the Boundary Waters Treaty, and it's interesting to note that it's two states that are putting authority in some regard to the shared watercourses in an external Oregon, and actually the Boundary Waters Treaty, the International Joint Committee is composed of 3 commissioners from Canada and 3 commissioners from the U.S. And they're required to act not in their capacities as a delegate of the U.S. or delegate of Canada, but as a member of the International Joint Commission. And so you can see here this idea of limited territorial sovereignty in a certain sense. And specifically, I've got an example of the Cabin Creek coal mine on the Flathead River Valley. And this was a matter that was referred to the International Joint Commission under its reference powers. And it was able to give a reference decision and an advisory opinion. And essentially, it came back and said that the proposed Cabin Creek coal mine in British Columbia shouldn't be built. And this, even though it's a reference opinion, created an uncomfortable political environment for British Columbia to go ahead with a project that had been denounced by the International Joint Commission. And so you can see that in some sense, there's been some discussion that British Columbia has been more reticent to put matters before the International Joint Commission since then, and the idea that it would be abandoning some of its abilities to approve projects within its own territory. So, and in that particular reference, they pinned their decision on Article 4, again, transboundary pollution. Compulsory, advisory, administrative, and arbitral jurisdictions. These are the different jurisdictions of the International Joint Commission. Compulsory, it has the ability to set orders for proposed works that would affect the level of the boundary waters on either side of the border. And advisory, I've alluded to that. It only requires in the treaty that one party submit a matter for an advisory opinion, but in practice, the norm has evolved that both parties would submit it. Administrative, it has some administrative powers, particularly over the St. Mary and Milk River. And the arbitral jurisdiction, it has the power to settle disputes. It has to be referred to, a dispute has to be referred to it by both parties, though. So the Columbia River Treaty. You can see on the map that I've provided, although it might be small, you can see the amount of infrastructure that's been built on this river. And in red, I think circled in red, you can see the dams that, or the projects that were built under the Columbia River Treaty. It's a very important watershed. I think it's important to note, though, when we use it as a reference for a great example of downstream equitable benefit sharing, that it's between two countries. There's watersheds in the world that are, for instance, the Nile has many more riparian states. There's a lot greater difference in cultures and languages, and there's sometimes more acrimonious history between riparians. Canada and the U.S. have the benefit of a fairly cooperative relationship, a fairly shared language and culture, and it's only between two. And in this case, it was only negotiated between two state parties. In effect, the province of British Columbia essentially took the lead for the government of Canada, but it was the government of Canada and the federal government of the U.S. that had the authority to negotiate this treaty. So it's a 2,000-kilometer or 1,200-mile journey from the interior of British Columbia to the Pacific Ocean. It passes through British Columbia, Canada, and then it passes through the portions of 7 U.S. states: Washington, Oregon, Idaho, Montana, Nevada, Utah, and Wyoming. So the Columbia River Treaty, it was concluded in 1961. It didn't enter into force until 1964. There had to be subsequent agreements between the federal government of Canada and the province of British Columbia. It addresses the cooperative management of the Columbia River, and it really focuses on two things. It focuses on power generation and flood control, and the sharing of the associated benefits of those downstream benefits between the parties. It addressed the historical problem of flooding downstream, particularly in the United States, and the need for power generation by managing the upstream dams in a efficient and optimizing way. Currently, there's a heavy amount of infrastructure, as I showed you in the last slide, and it's worth a lot of money too. For instance, the Canadian entitlement, which is under the treaty, the U.S. promised to give Canada 50% of the downstream power benefits, and this represents around 200 to 300 million per year to Canada, and particularly to the British Columbia government. The one thing, it's important to note that the Columbia River Treaty didn't take into account many factors, including ecosystems and subsequent damage to ecosystems, damage to fisheries, displacement of local populations. Local populations weren't really consulted in the negotiation of this initial treaty, nor were First Nations and Indigenous Aboriginal populations really involved in the same extent that they might be today, or should be today. And so it's important to note that this was a simple treaty in some respects. Regarding issues, we're just focusing on two issues between two generally cooperative riparians. The treaty runs in perpetuity. However, in 2014, either party could give 10 years notice to terminate the treaty. In 2024, if there is no agreement to the contrary, the coordinated flood control portions of the Columbia River Treaty expire, and then it would move to an on-demand system where the U.S. would have to request Canada to administer flood control or administer the dams in a certain way to provide flood control, and they would have to pay on a case-by-case basis in that sense. It's also important to note there's some dissatisfaction on both sides of the border with this treaty. I think there's often a lot of discussion about the Canadian entitlement on the U.S. side of the border, and the Canadian side of the border, especially in the basin. A lot of local communities, local residents felt that they they suffered most of the hardships, being displaced and having their communities flooded, but haven't necessarily received the lion's share of the benefits in that sense. And even today, there's some inability to use the reservoirs as they would like to. So as of December 7th, 2017, the U.S. Department of State has announced that Canada and the U.S. would begin to negotiate to modernize the 1961 Columbia River Treaty. So as I've talked about in the last slide, it had the 64 or 61 treaty, as you want to call it, had clear-cut objectives. The U.S. wanted flood control and optimal hydroelectric power generation. Canada wanted to build infrastructure and wanted to receive payment in return for power benefits. So the British Columbia government had great power in making this treaty. Today, there would be some different issues. Other things would have to be taken into account potentially. I've got some of them listed down there, but I'll talk about them in the next slide as well. But it's also important to note that both BC and the U.S. They have anticipated the idea that this treaty would be modernized. They both conducted studies and they've conducted and released recommendations regarding the future of the Columbia River Treaty. The Canadian or the British Columbia position was that the existing treaty framework should be preserved and a new modernized treaty should be negotiated within it, or the treaty should be updated. The U.S. Recommendation certainly included some changes to some of the provisions. And I think, what we're seeing now is a modernized, the treaty hasn't been, no one's given notice to terminate the treaty. What has happened is the beginning of a modernization negotiation. It remains to be seen where that leads to. I think in the upcoming, if the treaty is to be renegotiated in a meaningful sense, they may encounter more issues. There may be more issues on the table. More parties may be represented. We may see, obviously, tribes and First Nations in Canada and in the U.S. May be represented more in future negotiations. In Canada, there has been a real development in the law of Aboriginal peoples and the legal voice that they have in the courts of Canada. I have a quote there from R.V. Chilcotin, which really entrenched Aboriginal title and this duty to consult and accommodate by the government, the provincial and federal governments of Canada. So, and also I think you'll see perhaps more local community involvement. There are certainly more resources. There's organizations such as the Columbia River Treaty Local Governments Committee in Canada that are dedicated to trying to inform local communities and to have their voices heard. And I think, as I said, you'll see more non-state involvement and also more account of ecosystem services. Certainly in the recommendations that were released, that was highlighted as something for modernizing the treaty, but remains to be seen if that's preserved under the, it's a different, the recommendations were put forward in a different time, and sometimes policies change in that regard. So some further reading, for those interested in international watercourse law, there's great work by Professor Stephen McCaffrey. He was instrumental in the adoption of the 1997 UN Watercourses Convention. Richard Paisley has done some great work in the Columbia, especially in regards to the role of Indigenous and Aboriginal peoples in future negotiations. He also has a great website at internationalwatersgovernance.org. Nigel Banks and Barbara Cosens have also done some really excellent scholarship in regards to the Columbia River Treaty. So, and as I said, Oregon State University has the Transboundary Freshwater Dispute Database, which is also very useful. So thank you very much.
With that, we'll throw it over to Phoenix and Rhett.
Hi, as Eric introduced, my name is Rhett Billingsley. I'm a director at Fenimore Craig here in Phoenix, Arizona. I've been practicing law since 2005 in water resources and environmental law. And I spent the last year, 9 months at the Central Arizona Project and just returned into private practice. Before I get started, I just want to say thank you to Eric Martin and Francis Harto at Rocky Mountain for inviting me to participate in this talk. It's not sure if I qualify as a young professional anymore, but it's a really interesting topic, and I was happy to be invited to speak on it. So let's jump into it. So my presentation is going to focus on two river basins in the southwestern United States, the Colorado River and the Rio Grande. I'm going to provide some basic summary of the basic legal doctrines that govern interstate water allocation in the United States. move in and provide some more specific background on the Colorado River and the Rio Grande basins, and then also discuss two important water treaties between the United States and Mexico that govern use of those water resources. And then at the end, get into an example of kind of fitting with the title of today's presentation of conflict and compromise, an example of a conflict that's going on in the Rio Grande Basin with respect to the Texas v. New Mexico litigation, and both compromise in the Colorado River Basin with a recent mint that was entered into, which is like an amendment to the 1944 Water Treaty between the United States and Mexico. So this is a map of interstate streams in the United States. It's from the U.S. Geological Survey. It's an online GIS mapping program, and I just wanted to provide this is kind of provide some context what we're looking at today, and also just give a sense of the number of interstate streams there are in the United States. It's you know, streams do not follow political boundaries often, and so because of that, we need legal mechanisms to resolve disputes and allocation of those water resources. We're going to be focusing in on the upper and lower Colorado River basins, as you can see down towards Mexico, and the Rio Grande Basin. So interstate water allocation. In the United States, use of water is mostly a matter of state law within a state, but if we have interstate water sources, we need mechanisms in order to control how those water sources are going to be allocated between the different states. There are two important overarching federal law requirements, however, that control the means that are available to allocate those water resources. First, under the U.S. Constitution, states are not allowed to enter into an agreement with one another without the consent of Congress. So states cannot simply just go out and reach an agreement among themselves without getting some federal involvement and the approval of Congress for those agreements. We'll talk about that more. And then second, as disputes between states, the United States Supreme Court, under federal law and the U.S. Constitution, has original and exclusive jurisdiction over any litigation between states. That narrows the venue of and options for litigating disputes over water resources. So with that framework in mind, there have really been kind of three basic legal mechanisms that have developed for allocating water resources within the United States. The first mechanism is an interstate compact, and this is essentially just an agreement among the states about how they're going to divide up that water source. As I mentioned on the last slide, Congress must consent to any agreements between two or more states. And typically what happens with an interstate compact is Congress provides consent for the parties to go forward and negotiate the agreement. The states will negotiate the agreement, enter into it, ratify it, and then Congress will ratify and approve that agreement. And when it's approved and ratified by Congress, that becomes federal law. The second, and this is by far the most common mechanism that's been used to allocate interstate streams in the United States. I think there's some 26 interstate compacts in the United States dividing water resources. The next mechanism that's available is to file an original action with the Supreme Court to seek an equitable apportionment of the water resource at issue. So, as I mentioned on the last slide, the Supreme Court has original and exclusive jurisdiction over lawsuits between states. The Supreme Court has developed a federal common law doctrine of equitable apportionment for allocating that water. Essentially, under the equitable apportionment doctrine, the court will look at numerous factors to kind of arrive at a just and equitable allocation of those water resources. And some of the factors that the court will look at include climate, existing and planned uses of the water resources, availability of water storage, and importantly, what are the relative upstream and downstream harms and benefits to the states that are seeking that equitable apportionment. You know, there have been several equitable apportionment cases brought before the Supreme Court, but the Supreme Court has rarely issued equitable apportionment decrees. There's only 3 decrees that have been issued, one for the Laramie River, the Delaware River, and the North Platte River. And a lot of the other cases, the court found for one reason or another why it would not issue an equitable apportionment decree. Often it's because it found that the complaining state didn't meet its burden of proof. It's a very high burden of proof in these cases, clear and convincing evidence, and need to meet the factors that the court would consider in agreeing to provide an equitable apportionment. The last and least common mechanism for allocating water resources that's been applied in the United States is just a direct congressional action, and this is very rare. I think there's only one really clear example of that in the lower Colorado River Basin and the allocation that was made between Arizona, California, and Nevada under the Boulder Canyon Project Act in 1928. And I'm going to talk about that in more detail in a bit. So I'm going to transition into giving some more background on the Colorado River and the Rio Grande. The Colorado River, this is another map by the U.S. Geological Survey, provides an overview of the Colorado River Basin. I think there are some important things to point out on the map that are relevant to how water has been allocated in the basin. One, you can see that the basin's been divided into an upper and lower basin. That division legally, it's not really a hydrological division. It's legally been made at Lee's Ferry. It's a point on the Colorado River south of the Arizona-Utah border state line. So above that, upstream of that is the upper basin, the states of Wyoming, Utah, Colorado, New Mexico, and Arizona has a very small portion of the state within the upper basin, but typically hasn't been considered an upper basin state. The lower basin states that are Arizona, California, and Nevada. Other important thing to point out on the map is two large storage reservoirs that are very important for the management allocation of water in the Colorado River Basin. These are Hoover Dam, which forms Lake Mead, that's located on the Arizona-Nevada border near Las Vegas, and Glen Canyon Dam, which forms Lake Powell, and that's located upstream of Lee's Ferry near the Arizona-Utah border. These are massive reservoirs. Respectively, I think it's about 35 million and 33 million acre feet they store. An acre feet for folks in Canada is about I think 43,000 cubic feet, something along those lines. But it's a very large amount of water, and respectively, Lake Mead and Lake Powell are the first and second largest storage reservoirs in the United States. And the coordinated management of these rivers is very important to the management of the river, and for the lower basin has been important in the last years of drought and keeping us out of going into shortage. So in the Colorado River, you'll hear the term law of the river. There is no singular law of the river. This is referring to a body of law that's developed over the last 90 plus years governing the use of water from the Colorado River Basin. It includes interstate agreements, compacts, court decisions, acts of Congress, actions by the Secretary, and international agreements or water treaties that have been entered into that are governing those water resources. And in that sense, the Colorado River really is kind of a mix of those legal mechanisms that have been developed to allocate water resources between states. We've employed a lot of those different mechanisms in this basin. On this slide, this is really, though, there are some key legal actions that have taken place to divide the water in the Colorado River Basin. The first of those was in 1922. The 7 basin states negotiated, and the commissioners signed Colorado River Compact. That made the initial division of the basin into the upper and lower divisions and divided, with each basin receiving a 7.5 million acre foot allocation. Subsequent to that, Congress enacted the Boulder Canyon Project Act in 1928. That act ratified the compact. It did so on a couple of conditions. One was the condition that either all of the states would ratify the 1922 compact, or 6 of the states would ratify the compact, including California, and California would agree to limit its consumptive use to 4.4 million acre feet per year. Arizona did not ratify the compact until later in 1944, but because those other conditions were met, the act went into effect, and it authorized the construction of Hoover Dam and Lake Mead, and it also made an apportionment of the lower basin supply of the Colorado River. In 1948, the upper basin states entered into the upper Colorado River Basin Compact to allocate the supply among those states. Because Arizona has that small piece in the upper basin, it was allocated 50,000 acre feet off the top of the upper basin supply. The remaining supply is then allocated among the other basin states. And the last, I think, really important kind of allocation action that was taken in the Colorado River Basin was the Arizona v. California litigation, the 1963 decision, opinion, and the 1964 decree. And this confirmed the apportionment that was made in the Boulder Canyon Project Act in 1928 among the lower basin states. there was continued dispute between California and Arizona as to whether or not that allocation included the tributary flows within the lower basin states. And ultimately, Arizona, taking the position that it did not include the tributary states, the Supreme Court agreed with that position and found that, yes, there was a statutory apportionment between the states, and they did not include the tributary flows, which was very important to Arizona because we have the Gila River watershed, and Arizona is a big tributary and would have cut significantly into the Colorado River apportionment that we were provided. So moving on to the Rio Grande. The Rio Grande is the fourth longest river in the United States. It's a large basin that originates in Colorado, flows through New Mexico and Texas, and discharges into the Gulf of Mexico. And also forms a large portion of the international boundary between the United States and Mexico along the Texas state line. Development of water resources in the Rio Grande Basin began in the early 20th century. And in 1905, Congress approved the Rio Grande Project as one of the first and large federal reclamation projects that were approved to develop water resources and encourage use of those resources within the western United States. And a big part of that project was the construction of Elephant Butte Dam and Reservoir. The states of the basin, Colorado, New Mexico, and Texas, later in 1929 entered into an interim compact, and then into a final compact in 1938 to divide the waters of under the Rio Grande Project, and that was approved by Congress in 1939. This compact and the project covers a portion of the Rio Grande Basin north of Fort Quitman, Texas, Fort Quitman, Texas, and it's basically the upper portion of the Rio Grande Basin. So, like the Colorado River Compact, the Rio Grande Compact provides a division of the water between the compact states and provides water delivery obligations for Colorado and New Mexico, delivering to the downstream states. Colorado has a delivery obligation to deliver to the New Mexico state line. New Mexico has a delivery obligation, but it's to Elephant Butte Dam and Reservoir. And that is an important fact for the litigation we're going to talk about in a few minutes with Texas v. New Mexico, because that reservoir is located about 100 miles north of the Texas state line. And that's resulted in water being delivered to that reservoir, but then allowing for water uses to develop south of that reservoir that have alleged to interfere with what should be water that should be delivered to Texas. The Texas, like the Upper Basin, Colorado River Basin Compact, is administered by a commission consisting of representatives from each state, and there's also a federal representative that's appointed by the President of the United States. So I'm going to provide a little bit of background on two water treaties between the United States and Mexico that relate to the Colorado River and the Rio Grande. The first is the 1906 U.S.-Mexico Water Treaty. This is one of the first binational water agreements that was entered into between the United States and Mexico. And the treaty relates to water from the Rio Grande Project. It obligates the United States to deliver 60,000 acre-feet per year to Mexico from water from that project. It does provide some flexibility to the United States during times of extraordinary drought, or if there is accident in the irrigation system in the United States, to reduce those deliveries proportionately by the same proportion that they are reduced in the United States. The other water treaty between the United States and Mexico is the 1944 U.S.-Mexico Water Treaty. This treaty governs the waters of the Colorado River, Tijuana River, and the Rio Grande. And importantly, this treaty also created the International Boundary and Water Commission, which oversees boundary and water treaty issues between the United States and Mexico. The the Boundary and Water Commission was also authorized to develop rules and minutes for treaty interpretation and administration. And those minutes, once adopted, become basically supplemental agreements on how the treaty is to be administered. And they've been very important. There have been several minutes that have been adopted by the Commission that are important to the administration of the water, both in the Colorado River and the Rio Grande basins. So as far as water divisions, the 1944 treaty requires the United States to deliver 1.5 million acre-feet per year to Mexico, with an obligation to deliver 1.7 million acre-feet in years of surplus, and also the ability to reduce deliveries proportionally in times of extraordinary drought. In the Rio Grande, there's kind of a reverse delivery obligation. For Mexico has a right to 2/3 of some major tributaries to the Rio Grande River, but must deliver 1/3 of the flows of those tributaries to the Rio Grande, and the United States has all of the rights to the U.S. side tributaries to the Rio Grande. And this is governing the use of the Rio Grande below Fort Quitman, Texas, so below the Rio Grande Project and the Rio Grande Compact area. So I'm going to get into a discussion of litigation in Texas v. New Mexico, and then also talk about a recent minute that was adopted to the 1944 Water Treaty. So in 2013, Texas brought a legal action in the Supreme Court alleging that Mexico was in violation of the Rio Grande Compact by allowing diversions of surface water and groundwater below Elephant Butte Reservoir, maintaining that New Mexico was required to deliver a minimum amount of water to Elephant Butte Reservoir, and that amount was reserved for Texas. In defense, New Mexico's position in the lawsuit was that it's not in violation of the compact, that the compact requires it to deliver water to Elephant Butte Dam and Reservoir. It's doing so, and that the compact did not prohibit further development of water resources downstream of that reservoir. So in 2014, the Supreme Court granted Texas motion for leave to file a complaint, and the United States also moved to intervene in the lawsuit and file a complaint and intervention. The United States alleged that it had a distinct federal interest in the lawsuit because of its obligations to downstream contractors of the Rio Grande project, and also its obligations under the 1906 Water Treaty with Mexico to deliver water from that project. New Mexico moved to dismiss both of the complaints, and with respect to the United States, argued that the United States was not a party to the compact, and the compact did not provide the United States with any right to enforce that compact. And these arguments led to a recent Supreme Court decision that was issued in March of this year, kind of resolving these issues and the ability of the United States to intervene in these types of lawsuits. So in March, so with respect to the administration of lawsuits, so in an original action before the Supreme Court in these water cases, the Supreme Court's not a trial court. It's not suited to hear evidence and all the motions that are filed in the lawsuits. So a special master is invariably appointed to oversee the administration of these suits, to hear evidence, to take the motions, and then provide a report or recommendations to the Supreme Court with respect to how it recommends that the court should decide those issues. Here, the special master considered the motions dismissed filed by New Mexico and recommended actually dismissing the United States claims, finding that the U.S. did not have a right under the compact to enforce its terms. The United States filed an exception to that report with the Supreme Court, which resulted in the Supreme Court taking up that issue. And in March, the Supreme Court issued a unanimous decision that the U.S. would be allowed to pursue its claims under the compact. And there were some important factors in that decision. The Supreme Court's decision is very narrow, and the issue that it addressed and really is, could the United States intervene and assert essentially the same claims that Texas had been asserting in the litigation? It was not seeking to expand the scope of the litigation or to initiate its own lawsuit. It was just intervening within the same scope. And the court found that the United States claims were intertwined with the compact and operation of the Rio Grande project for downstream users. Also found that New Mexico had conceded that U.S. was an indispensable party, played an integral role in the operation of the Rio Grande compact and the project, and that if New Mexico was in violation of the compact, that could interfere with the United States' ability to fulfill its treaty obligations to Mexico to deliver water. And then I think a really important factor in the decision was that the United States was essentially asserting the same claims. It wasn't trying to expand the scope of the litigation. And so within that, the court didn't really provide any guidelines for future decisions, but I think this decision stands for the point that there is an opportunity, I guess, for the United States to intervene in these types of lawsuits so long as it's not seeking to expand the scope of litigation and has a distinct federal interest in the lawsuit. So now with the United States participation, this lawsuit is going to continue with the court's consideration of Texas and United States claims, and we will see where it goes. So last topic I was going to address was the recent minute that was entered into to the 1944 Water Treaty. So as I explained, the minutes are essentially supplemental agreements to the Water Treaty as far as its administration and interpretation. In 2012, Amendment 319 was entered into to address some water management issues on the lower Colorado River, included several provisions relating to sharing of shortage, that is both the United States and Mexico taking reductions in deliveries during time of shortage, surplus sharing, the two countries sharing in surplus, being able to increase diversions in times of surplus, in addition to conservation and environmental projects and salinity management on the Colorado River, which has been a major issue in the lower Colorado River and the deliveries that are made to Mexico. That was set to expire at the end of last year, and the United States and Mexico were able to negotiate a successor agreement to that, Minute 323, which builds upon the provisions of Minute 319 and includes several additional provisions to help with drought and environmental management in the Colorado River Basin. Just a quick summary of the terms of Minute 323 with respect to water management. It continues the commitment to cooperative water management in the Colorado River Basin, providing for the surplus and shortage sharing. Also included a commitment for investment by the United States and non-federal funders for conservation projects and environmental projects in Mexico, both to address the environmental issues and to create system conservation and more water within the system. Included a commitment to pursue a study of binational desalination in the Sea of Cortez or Gulf of California region as a potential augmentation supply in the future. And to provide for additional projects for addressing salinity issues on the lower Colorado River. There are already mechanisms and obligations in place to try and reduce the salinity of the water that is delivered to Mexico, and this minute expands upon those. Importantly, the minute also creates a binational water scarcity contingency plan, and this is a plan that effectiveness of this would be tied to the lower basin states in the lower Colorado River adopting the lower basin drought contingency plan. This would be where the states would agree to additional shortage reductions in order to, in the event of a shortage, prevent even more drastic reductions in the levels of Lake Mead and deeper shortage. And if the United States, lower basin states, enter into this and that becomes effective, then Mexico has agreed to also take some additional reductions in their water deliveries to help with that effort. And lastly, there are other provisions of this, but for Mexico, this provides the ability for Mexico to store some water in U.S. by reducing their delivery orders. They can take that saved water and actually store it in Lake Mead and be able to have access to those supplies in other years. So that concludes my presentation. Thank you for listening, and I'm happy to take questions, or I'm sure if there are questions for Cody, then he'd be happy to pop up.
I have a question.
Yeah.
How do the courts interpret or what weight do they give to the orders of the International Boundary Water Commission as compared to the terms and conditions of the compacts, and how do they weigh those when there's a dispute or in interpreting the provisions of the minutes versus the compacts, et cetera?
Well, they would be with respect to the disputes between, a federal dispute between Mexico and the United States, and so I guess there maybe wouldn't be necessarily crossover there with respect to our obligations to Mexico or under the 1944 Water Treaty, and that would be an interpretation and administration of that treaty. And so, as far as what the states have agreed to for their individual water allocation between the states, I don't know that would be relevant. I don't know of a court decision actually addressing that issue, though. That's my supposition.
Questions for you guys?
Happy hour?
Eric, you're self-muted.
All right. My question was concerning the two treaties that seem to kind of kick things off between the U.S. and Canada and the U.S. and Mexico. Both seem to be around 1906. And I was curious if what was going on at that point that kind of drove the U.S. and Canada, Mexico, Canadian-Mexican governments to enter into those treaties. Was it a hydropower issue? Was it agricultural issues? What were kind of the driving concerns?
I think I can up in more.
You don't know, sure.
But anyway, the as far as the Boundary Waters Treaty goes, I mean, it was initially negotiated between the United Kingdom and U.S. to provide for the navigation and the maintenance of these shared resource between the two states. And in regards to the Mexico-U.S. boundary, a lot of the negotiations, and Brett can probably speak more closely to these, but a lot of the initial agreements were negotiated out of a desire to secure water for agricultural purposes in the U.S. and there was often there was kind of a trade-off between the Rio Grande and the Colorado. Mexico got more use out of the Rio Grande, and the U.S. was allowed to extract more water out of the Colorado in exchange. And so there was, I think it was at a time when both Canada and the U.S. and perhaps Mexico and the U.S. were trying to secure their water resources and provide some reliability to those.
Yeah, I would agree with that. With respect to the Mexico treaties, I think they were initiated, from what I've read anyway, because of projects and water development that was taking place in the United States. So with the 1906 convention, the Rio Grande project was approved in 1905. Elizabeth Dam and reservoir were being constructed, and I think that there was some concern about how that would impact water resources in Mexico. And with respect to the 1944 treaty, there was increased development of water resources following the construction of Hoover Dam, and in the lower Colorado River that I think rose concerns about making sure that there was an international agreement with respect to our delivery obligation to Mexico.
Thank you. Any other questions? If not, we will transition to the networking event at those locations that haven't done that yet. Please join me in thanking both Cody and Rhett for sharing their thoughts on North American and international water resource allocation issues. And thank you all for joining and attending. We're done.